Now, Section 4 of the Road Traffic Act 1988 is driving whilst unfit through drink or drugs. It's an offence that I describe as being quite outdated, but in this video we're going to be talking about what Section 4 is, the kind of sentence that the court can impose for a Section 4 offence, and some of the most common defences that you see being raised as well. Now, Section 4 of the Road Traffic Act 1988, it does still apply, it still exists, but you don't see the police prosecuting all that much for Section 4 offences anymore, and that's because they can be quite difficult to prove. The main difference between Section 4, driving whilst unfit through drink or drugs, and Section 5, drink driving, or Section 5A, drug driving, is the requirement on the police to prove that a person is impaired. Now, in Section 5 or Section 5A cases, again that's drink or drug driving cases, there's no requirement. It's not necessary to prove that a person was impaired as a result of a substance they'd consumed. It's only necessary to prove that they were above a legal limit. And that, of course, is easier for the prosecution because they're going to rely on breath results, blood results, urine results in those cases. Whereas Section 4, they don't have to prove necessarily that a person was over the legal limit. They've got to try and demonstrate that you were impaired as a result of a substance which you've consumed. And that's more difficult than it might sound for various reasons. The main reason is because different things can cause impairments. The police might say, well, Tommy was impaired because his eyes were glazed, or Tommy was impaired because his speech was slurred. But everyone knows that it's not just alcohol that might lead to your eyes being glazed or your speech being slurred. It might be that Tommy suffers with anxiety. It might be that he's just finished a long shift at work and he's tired, he's exhausted. So there are different things that can cause impairment. It's very difficult for the police to isolate the impairment in a Section 4 case directly to the drug or alcohol consumption. That may require some expert evidence, which they don't always have in these kind of cases. So not the easiest type of offences to prosecute. Now, of course, that means if you're in a situation where you've been charged with a Section 4 offence, that may mean that it's easier to defend than Section 5 or Section 5A. So always well worth considering your options and try and get some independent legal advice if you can, because you might find that these cases are a little bit easier to defend than you first thought. Now, as far as sentencing is concerned, Section 4 offences are similar to failed to provide offences in sentencing, in that because there doesn't have to be an alcohol or drug level, the court will instead consider the level of impairment in a person, a bit like in failed to provide cases. So if the level of impairment is minor, if there's only minor evidence or limited evidence that a person was impaired, then you're likely to receive probably a 12-month driving disqualification. It can go up from there. Typically, you can't get less than a 12-month driving ban in a Section 4 case. If there's evidence of serious impairment, and that could be a car accident, if you're really slurring your words, if you're really unsteady on your feet, then of course the police will make a point of that, and that may increase the driving disqualification. If you've got previous convictions for similar offences, then it could be 3-year driving disqualifications as a minimum as well. I'm sometimes asked, does the drink drive rehabilitation course apply in Section 4 cases too? It does, but only where the Section 4 charge is driving whilst unfit through drink. Clearly, if it's a driving whilst unfit through drug charge under the Section 4, then the drink drive rehabilitation course wouldn't apply. They haven't yet developed a rehabilitation course in drug driving cases. And the drink drive rehabilitation course will reduce the driving ban by 25%. So if you were to get the minimum, which is 12 months, then that's going to reduce that to a 9-month driving disqualification. So well worth asking the court for that. Now, as far as the circumstances when the police prosecute for Section 4, well, Section 4 is quite a broad offence. That means there's lots of different ways in which the police can prosecute for a Section 4. If you go to the police station and you refuse to give a sample of breath or blood or urine, and you're then charged with fail to provide, technically the police can also prosecute you for a Section 4 charge alongside that, because they will say on the one hand that you failed to provide a sample of breath. They'll also say that there's good evidence that you were driving whilst you were impaired, you were driving whilst unfit. If you give a sample of breath, blood or urine at the police station, and for whatever reason the police can't rely on that evidence, that's excluded, or the results come back and they're unreliable, the police could in those circumstances prosecute you for a Section 4, because remember, the key difference is they don't have to have results that put you over the legal limit in order to prosecute you for a Section 4 offence. Let's also have a think about some of the most common and the most effective defences that you can raise to a Section 4 allegation. Now, the first, and arguably the best, is that you weren't impaired as a result of a substance that's been consumed. Remember that it's not enough for the police to prove that you were impaired in a Section 4 case. They've got to go one step further, and this is perhaps one of the reasons why Section 4 charges are less common now than they ever have been before, because there are easier offences that the police can prosecute for instead. So it may be that you accept that you were impaired impaired, and perhaps challenging that aspect of the case is never going to work anyway based on what a police officer is going to say in his statement or in court, which the court may accept. But if you accept that you were impaired, but you weren't impaired as a result of alcohol or drugs, then you're not guilty of an offence of Section 4, because they've got to establish that causal link between the impairment and the substance that's being consumed. And this is going to be especially difficult if there was no evidence of alcohol or drug consumption, or where that evidence is very, very limited. Like maybe that you appear impaired because you're tired. It may be that you take prescription medication that might make it appear as though you are impaired. It might be that you have mental health issues. There might be autism or learning difficulties in your case that may make it seem as though you are impaired. Now, also remember that a lot of the defences that apply in drink and drug driving cases also apply in Section 4 cases as well. So the procedure at the police station, how you were processed, and whether the police complied with their codes of practice. If they did try and take an evidential sample from you, then were you given the statutory warning? Was there an MGDDA or MGDDB document? You can read and learn more about those in our other videos. If they tried to take a sample from you, can that sample be used? Is it admissible? Was it taken in a lawful way? And then finally, prosecution disclosure, which if you've listened to any of our other videos, you'll know we talk a lot about prosecution disclosure in these kind of cases. And in summary, that means whether the prosecution provide the evidence in the time given to them by the court. So if we enter a not guilty plea in a Section 4 offence, then as always, the CPS only have a limited amount of time to provide the evidence against you under Section 3, the Criminal Procedure and Investigations Act, and also the Criminal Procedure Rules. And what happens more often than not in these kind of cases, whether that's because they're considered low priority or whether this happens in all criminal cases, but often the CPS don't provide the evidence in time. They don't comply with court directions, and that can lead to evidence being excluded, which means it can't be used against you. Now, if the police have a particular piece of evidence which they need to use to prove that case, and that evidence is excluded because it's not served in time, then your case would normally fail as a result of that. So Section 4 offences are possibly some of the most difficult driving offences to prove because of the various elements, how technical they can become, and because of that added issue of impairment. So if you are in a situation where you've been charged with a Section 4 offence, then always try and get some advice to start with, because a solicitor should be able to talk you through your options, defence arguments, sentence if you are convicted as well. It's worth knowing because you can get disqualified for Section 4 offences. If you'd like to discuss your own situation with us, and you'll find our contact details on our website, and again, you'll find our contact details in the description of this video as well.